House Bill 459 is the cross-file to Senate Bill 691, which makes numerous changes to the juvenile justice process by generally implementing the recommendations of the Juvenile Justice Reform Council. So the House bill, as it originally came into the House, was not quite identical to the Senate bill. So the House put amendments on it to make it identical to the first reader version of Senate Bill 691, which was subsequently amended both in the committee and on the floor. Correct.
All right. So the motion's conform House Bill 459 with Senate Bill
691.
691 that we passed and amended on the floor in here. All right. There's seconded. Everyone will record the same vote as before. So,
You're a no.
Senator Cassidy's a no.
I don't have everybody's vote in front of me, so.
All right, so is Senator Wallstreicher, yes, Senator Lee, yes, Senator Cassidy, no, Senator Hedelman, yes, Senator West, yes, Senator Sidnor, yes, Senator Watson, yes, Senator Bailey was a no. Senator Carter was a yes, because it was her bill, and Senator Huff was, did you go up or down on this one? You went up on, so you're down on this one.
Is that, well, wait, hold on, is that the vote for conforming it?
That's a vote for conforming.
Or is that the final vote? Is everybody agreeing to
Sa-
conform it?
Same.
Same and same.
Yep.
It was Senate Bill 279, right?
Yes.
691.
691.
Senate Bill 691? We're not even on the list.
We're
So-
getting a new copy, but our machine is broken in the back, so they've got to go over. So, here, I can pull up
Oh,
the vote.
juvenile justice reform? Oh, yeah, I'm a no on that.
Yeah, you're no.
We're conforming, but I'm still a
Wait a minute,
no.
let me make sure.
Oh,
I'm
Lord.
looking at the final.
You went no on the floor, Chris.
I went no on the floor, so I think I'm.
Are you no on the amendment or just the bill? Just, okay.
So there are two questions.
Same.
Well, you want to be yes on the amendment.
Yes,
You conform it.
No on the bill, or no on the
You
floor.
want to be yes to conform it, because that, the amendments we want, and we want to be no on the bill. Yeah, that's a big difference.
So, 4 no's, 7 yeses. Well,
You got one person out. Yes, it would be, but.
So this is House Bill 571. This is the bill that altered the access to counsel and eviction special funds source to include final settlement agreements or judgment related to an investigation or enforcement of the Maryland Consumer Protection Act for an unfair, abusive, or deceptive trade practice regarding residential rental property, excuse me. The House bill was the same for the Senate bill, except it replaced the phrase "money received by the aggrieved party" with restitution. I did check with the OAG's office. They would like the term restitution used in order to parallel the opioid restitution fund for clarity. So the recommended is a favorable.
All right, so did the House make that amendment, or is that amendment floated afterwards?
The House already did that to the House bill, so we're voting favorable on the House, and they'll make the change to the Senate bill.
Okay.
We voted unanimously in favor.
They voted against Boston, they're like,
All right, so motions for favorable.
I got right. Second.
Everyone's okay? All right.
You were opposed to
So Senate Bill 817 prohibits specified departments in the executive branch from declining to hire an applicant solely on the basis of a previous criminal conviction unless they make certain findings. And additionally, the bill requires a youth camp operator before making a formal offer of employment to a job applicant to request from the Department of Health a determination as to whether the results of a federal criminal history records check would prohibit the camp from hiring the applicant. There's an amendment that you will have, I think, which would applies the provisions relating to youth camps to specified youth development organizations or programs, and defines that term. And it also states that instead of requiring those entities to go to the Department of Health, it would authorize them to do so. So, yeah, the amendment would additionally apply the provisions that apply to youth camps to youth development organizations and programs, and defines that term. And it specifies that rather than requiring those entities to go to the Department of Health, it would instead authorize them to do so. So the bill has two parts, and I think there may be an amendment to one of them. So the first part prohibits certain specified executive branch departments from declining to hire an applicant solely on the basis of a previous criminal conviction unless they make certain findings. And then the second, largely unrelated provision of the bill deals with youth camps and, as amended, youth development organizations and programs. And with the amendment, authorizes them to go through the Department of Health to conduct a criminal history records check. Yeah, so these youth camps used to go through the Department of Public Safety and Correctional Services, but there was a change in federal law which prohibited the department from releasing that kind of information to the camps. So the intent of the bill, and my understanding is the sponsor worked with the Department of Health, was to provide an alternative route by which they could go to a state agency to do a criminal history check to determine whether that person was a prohibited employee, because there are regulations which prohibit those kinds of entities from employing people with certain criminal convictions. So the way the bill is drafted for that piece which concerns certain departments is there are provisions in law which apply to executive departments which issue occupational licenses that say they are not allowed to decline a license solely on the basis of a conviction unless they make these findings. So what the bill does is it takes those provisions, which again only apply to the Department of Agriculture, the Department of Environment, Department of Health, Department of Human Services, Department of Labor, and Public Safety and Correctional Services, and adds in that they may not decline to hire an applicant solely on the basis of the conviction, but that would only apply to those specific agencies. Yeah, so the amendment would be, on top of the amendment that's being considered, would be to strike beginning with page 1, line 24, all the way down through page 3, line 15. And that would take those employment-related provisions out of the bill. Through page 3, line 15. So everything in the bill that's in the criminal procedure article.
Okay. Okay, so now we're just down to the health general piece. And
So
it's
now
only-
it would only be those provisions which say that with the amendment, it would say that a youth camp, a youth development organization or program may go through the Department of Health to request a criminal history check on a prospective employee to make sure that they are not disqualified from the job they're applying for. Correct. It's essentially the same check, but there was a change in federal law which the Department of Public Safety and Correctional Services felt like they couldn't continue the process that they were currently doing with criminal checks.
So when you read the departments, is Department of Natural Resources on there?
It was not. It's And that's the part that's being struck from the bill.
Okay.
And those, it's just the occupational licensing agencies.
All right.
So occupational licensing agency who is running a youth camp cannot deny solely on the basis of a criminal conviction, that's what this is gonna say?
No, so currently, there are two parts of the bill, and basically one is in the criminal procedure article, and one is in the health, I believe it's, yeah, it's in the health general article. Currently, they're not exactly related directly. So that first piece says that these agencies, which do occupational licensing, they're currently not allowed to deny a license solely on the basis of conviction with these specified exceptions. And the bill would also say they also cannot decline to hire an applicant on the same basis. And then there's another part of the bill which is largely unrelated, which is basically saying that these youth camps and youth development agents or organizations can go to the Department of Health to request a background check on a prospective employee, and the Department of Health would then advise them on whether that person is legally prohibited from getting the job that they're applying for.
Page 3, line 16, forget about it, it's irrelevant. It's being deleted, and all we're looking at is page 3, line 16 on, which has been amended.
The reprint does not have that piece about striking parts of the bill, so that would be on top of what's currently in the reprint when you get it.
Go through the department to do their background checks. That's it. That's all it does.
But are they giving them background checks, across the board, or are they picking and choosing who they're checking? Because it makes it sound like it's giving the department discretion.
So the way that the amendment would be, currently, the bill as drafted requires these organizations to do that. The amendment would change a shall to a may, so it's actually at the discretion of the youth camp which employees they do that for. And presumably, they would do it for those employees who they would be legally prohibited from employing if they had certain criminal convictions.
Because of currently they're doing background checks, but because of a change in the federal law, the department is saying, we don't think we can give you these background checks anymore because of a change in the federal law. And they don't have the ability to do the background checks on their own. So all it's saying is, we'll do these for you, what you're already doing to make sure that the people you're hiring have been cleared for these youth camps.
This letter from most networks, leaders in youth development, a change in federal law that requires a state agency to serve as an intermediary to receive results from federal background checks. Previously, many non-youth serving organizations like Girl Scouts, Kuwait, and Girl Scouts, and many others directly request and receive background information checks for new hires and volunteers. Therefore, a new system must be established to provide timely federal background check information to organizations.
That's it. That's all we're doing.
We support Senate Bill 7, or SB 817, with amended language to include a wider variety of youth-serving organizations. So it sounds like basically this helps them get background checks, is the summary, which is fine. Yes, got it.
Yeah. 4-H clubs that do youth camps in the summer.
So this is, you're not missing half of the amendment, so the amendment we just discussed with the striking everything except for the health general article is not here. This is not in here. I got it, all right. So we need to, we adopt this amendment before us? Everyone's okay with doing that? Okay, great.
We're adopting amendment 16365/1, that one.
Correct. Okay, now, Josh, can you just re-explain again the inline amendment that we're gonna have to make here?
So it's striking from page 1, line 24, all the way through page 3, line 15. So the bill is now just the provisions about youth camps and youth organizations going through the Department of Health to request background checks.
Because it's interesting that it explicitly puts in YMCA, Boys and Girls Clubs, Parks and Rec. What about what do, Boy Scouts and Girl Scouts or religious camps, why are we just writing in these groups versus, do the others, are they not using it? I mean, Boy Scouts, they gotta have a ton of these. Yeah, ones that have had problems in the past, or church groups or whatever. So why are we explicitly writing in these three groups?
These are, I presume, the groups that were involved in the discussions. I don't have any great insight into that, unfortunately.
I mean, just here's if we're trying to create a system where people can get background checks for camps with kids, why even go to the trouble of listing certain groups? Why wouldn't you want it so that Boy Scouts of America, Girl Scouts, I don't know,
So I will.
St. John's Catholic Church or whatever, whoever wants to go and do it.
So what it applies to is youth camps and then also youth development organization or program. And so that the limiting of it to specific organizations, that's in the definition of youth development organization or program. And then the provisions apply both to those and to youth camps. So it's not just those organizations, but I think there was a desire to make sure that those organizations were covered.
Because if you're a youth camp, then you're already covered, even if you're not listed here. These are development.
I mean, but there's other affiliates. So you're saying these YMCA. So this could be an after-school program. So yes, okay, the summer camps are covered, but the after-school programs may not be. Well, there could be, yes, I see a county or a program of recreation parks of a county municipal corporation. So county or whatever may be done. But what if the 4-H has some program or something? I mean, I just don't understand why we would want to.
So there is a definition of youth camp, which is in 14401, which is not in the bill, but it is any day camp, residential camp, travel camp, or trip camp that accommodates 7 or more campers who are unrelated to the person operating the camp, provides primarily recreational activities, or has a substantial outdoor recreational component, has permanent buildings, temporary buildings, or no buildings, and operates on owned private property, owned private facilities, leased private property, leased private facilities, public property, or public facilities.
So they would be, why wouldn't YMCA, Boys and Girls Club, and these other organizations that we are explicitly listed, they're covered in that definition too?
They likely would be.
Yeah, so there's no reason to explicitly list out organizations. I'm just worried that once you go into explicitly listing, yeah, it creates a problem. Whereas the definition, if it encompasses them now, we should just strike the organizations that are listed.
Programs that provide activities for school-aged children who are at least 5 years old. Stop there, and then delete the organizations.
Whether it's after school or summertime or.
Yeah.
I mean, that definition you read off to me completely would encompass. I would imagine anything.
I understand it was just discussions between the stakeholders. I wasn't involved in those.
Well, these are clearly the groups that wanted this, and they're trying to make sure they're covered, but it's unnecessary, because in the language and definition you read, they are covered.
Strike out of the everything but the health general articles. Can we make the amendment to just strike all that to from page 1 to line 3, line 15?
As long as
all
we're
right.
confident that definition, that a youth camp.
Is he gonna have to drop in a cross-reference for that, or are you gonna?
No, that's in the same subtitle,
Got
so.
it. All right.
Because I'm just, I mean, would a youth camp include just a church organization that people aren't staying at overnight? They're just,
Right, after-school programs.
they're just after school, they're just, yeah, Sunday schools.
Well, it's day camp, residential camp, travel camp, or trip camp. I don't have enough experience in here to give you a good
Yeah,
answer, Senator.
I just don't think of Sunday school as a youth camp. I mean, they do have summer camps where the kids go and stay all day long, and mom, dad pick them up at the end of the day, but
Why can't you just say youth development organization or program means organizations that provide programs, activities for school-aged children who are at least 5 years old, and get rid of 1, 2, and 3, the definitions, and just leave the rest of the bill alone.
Fall outside the purview of childcare licensing.
But I thought the bill provided that it's the department's discretion, so if they don't require, if they're not covered. If it doesn't require it, then the department will say, no, we're not doing that for you. You're not entitled to that. Because we took out the,
But I think we should, include them. We want youth-serving organizations, period.
right, so if we just say that youth development organization or program means a program that provides activities for school-aged children who are at least 5 years old, period. There's your definition.
Yeah, and then strike 1, 2, and 3 that explicitly names these, and leave the
That's
rest of
really
it
broad,
alone.
would include everything.
I'm good with that. Go broad.
So, why 5 years
Right.
I wasn't involved in the conversations where they came up with the language, so I couldn't tell you.
Yeah, I'm with you. A pervert and take care of 3-year-olds. Yeah.
No, but I assume they fall under different, like, childcare licensing requirements. But I don't know.
But if we just strike that, we're not hurting anything by striking the age limit restriction, because
Somebody said
Well, you
it has
could-
to be
Covered, you're
6
not
and
covered.
up.
Well, you say that how about this, provides activities for children,
yeah,
and just provides organization programs that provide activities for children. That's it.
period.
Oh, Office of Child Care, 0 to 5, MDH already licenses summer camps.
Oh.
Has to stay within a division of state government. It's probably fine.
So we had a bill, I don't think it came out of committee. This was Senator West's bill, person in position of authority, sexual offenses with a minor. And what we did was we laid out in that bill all the different types of organizations in which an adult would have to take care of these kids. And it seems like it was pretty inclusive of pretty much everything: sports, scouting, recreational activity, day or overnight trip, religious institution, any unit of local, state, or federal government, and it goes on and on and on. Is that appropriate?
answer with who regulates who, but. No, I'm talking about Shelley.
This is a person who represents the Boys and Girls Clubs. But, right, different agencies regulate different entities depending on the ages of children, too, and what they're there for.
Yeah.
So there's a youth club exemption in the child care licensing law right now. This is what I think this is meant to cover.
But by being general under the health general article, if these don't apply to them, then we're okay. We're just not excluding anybody. So
I
we
think
can be
that's right.
broad,
Yeah.
yeah.
It sounds like you're okay because if 0 to 5 is already covered under something else. Yeah, then I.
Do we need school aged?
really struggling. We've listened to this before, and I had to go through.
Doesn't look like either of them are defined terms in that part of the code. You could say child under 18 or under whichever age you thought were appropriate. Is that in?
Under section 14407, you would keep everything in A, you'd strike for school-aged, and just say minor. So it would read, in this section, youth development organization or program means the following organization or program. Yeah. Because we're not doing that.
Leave organizations or programs.
Organizations or programs that provides activities for a minor or for minors? For minors, period. And then strike subsection 1, 2, 3, all the way down to line 18.
Is this because of the federal change, or why are we going from a shall to a may?
So I would assume it's because it essentially applies to any job offer, which I'm not familiar with the regulations of the area, but it may be that not all job positions fall under the same prohibitions on employing people with previous convictions.
Who comes in on weekends and mows the grass.
All right, that's fine, but just the current law is not shall, is it?
So there is no current
There is
law
no
on this,
current
on this
law. Okay,
process.
that's fine, understand. Good. I'm good.
It's been seconded, everyone's good? All right. All right, Jamie, let's go to Senate Bill 752.
So Senate Bill 752 specifies the information that must be included in an incident report filed by a law enforcement officer pursuant to current law or a police officer under Chapter 59 of 2021 regarding a use of force incident in the line of duty. The bill also establishes requirements for local law enforcement agencies with regard to that information, specifically by January 1st, 2023, and every 3 years thereafter, each local law enforcement agency must publish on its public website the total number of reported use of force incidents for the preceding 3 months in which the local law enforcement agency determined that the use of force was or was not consistent with its policies and applicable laws. By July of 2024 and each year thereafter, each local law enforcement agency must publish on its public website the aggregate data of police officers' reported uses of force. So, There was some feedback during and after the bill hearing about some concerns over the requirements for the use of force incident reports. So if you're looking at the bill on the first page, just sort of for context, these reports are being filled out by law enforcement officers that used force, and they're required to be completed by the end of the officer's shift unless the officer is disabled. So there's the new requirements are on page 2 of the bill. There were some concerns that some of the information being reported could pose admissibility or Fifth Amendment issues because essentially you could be asking an officer to report things that might otherwise incriminate them or, pose an employment issue. And then also, there's some information where there was a concern that it may not be readily ascertainable. So if you're looking at page 2 of the bill, some of that information is ethnicity and disability. There were just concerns that a police officer may not be able to determine that readily. As for the other potential issues, there were concerns over the officer reporting on the officer's justification for the use of force, and
Jack.
I think that was the major issue.
It's in the testimony. It says, Senate Bill 752, this is police and sheriffs, requires officer to report on protected class memberships, both of these subject to use of force. Requiring an officer to self-identify his or her race or ethnicity is troubling. Even more concerning is the bill's requirement that an officer demand disability information of a citizen and share his or her disability status completely regardless of whether disability is in any way relevant to the incident.
Where's the report go?
Thank you. If question for Jamie, the Fifth Amendment arguments, would you mind talking a little bit more about that? And what are the issues?
Essentially, that they'd basically be in a position where, in order to comply with the requirement that they complete the report, they would basically have to provide that justification on the spot, and that I guess potentially there was concern that could be used against them.
Don't they have to? They have to do the report anyway, right?
Right.
So I mean, that argument doesn't hold water for me. I mean, they have to complete the report. So I mean, and they have to. I'm assuming they have to complete it honestly or truthfully. So I mean, I'm not. That's why I was curious. I'm not understanding this whole Fifth Amendment thing. So thank you.
I know all of last session was devoted to reporting and processes for reporting, and that stuff is still moving out. We've got police doing a whole bunch of reports now, and it seems like now we're starting back over from square one here. I mean, I would just be surprised how much of this stuff is redundant of what we just required the reporting on, and I think I don't think we should just dismiss the Fifth Amendment issues because the incident report, this is requiring the additional disclosures. See, I mean, if you look. Okay.
Jamie, let's go to Senate Bill 949.
So as drafted, Senate Bill 949 establishes 3 scholarships for police officers that must be awarded to all applicants that meet the eligibility requirements. The governor for fiscal 2024 and annually thereafter must provide sufficient funds in the budget to equal 100% of the value of the scholarships awarded. Additionally, the bill alters the duties and requirements for Maryland Police Training and Standards Commission and requires at a minimum that an individual seeking certification as a police officer hold an associate's degree and that a police officer hold a bachelor's degree within 6 years of being certified as a police officer. The requirements relating to MPTSC and degree requirements for police officers apply prospectively and do not apply to police officers certified before the bill's effective date. There is one amendment in your voting packet, that is Amendment 593223, and it strikes provisions of the bill relating to the requirement for an associate's degree and obtaining a bachelor's degree as requirements for certification, and also includes language, let me just make sure I'm getting it right, that alters the existing Edward T. Conroy Memorial Scholarship Program and Jean B. Cryer Memorial Scholarship Program to provide that those awards are available both to be used inside the state and outside the state.
Inside and outside the state?
Right, for that other scholarship program. And if you're looking at the,
So you have to be a Maryland resident at the time that your parent was killed?
so that's for the dependents of, right, dependents of fallen law enforcement officers, as well as there's a list. It's also applies to armed services members.
So it's like Ashley's bill.
Right.
Gotcha.
Get rid of the
Gotcha.
requirement or
Thank
get
you,
rid of
thank
the
you.
associate's
Right.
requirement.
Front. I mean, we demand so many reports tonight. Page 3, line 22 on the reprint, still requires, I mean, I just don't want to burden people with reports that don't mean anything. So we're just going to say every year they have to report the educational level of all of their other law enforcement officers, and then.
How we talked about this earlier, we're just gonna send them a GoCap and then they never get delivered. We already started this out earlier. That was awesome. They go to GoCap.
Yeah. And that's the end of it. They just go there. What does CAP stand for now?
Well, now we're gonna have a secretary that's gonna be accountable to us, okay?
Yeah, we get to advise.
Yeah, I just would like to say one thing, and it's not that I won't vote for the bill, but just to go back to what I think I said when you had the hearing. Law enforcement officers are being asked to apply legal principles, something that you had to go to school for 3 years for, and then take a test so that you could practice. Me and a few others on this committee. And to the pushback that the committee has gotten just to say that you have to have an associate's degree, I think it's ridiculous. I mean, given the technical, I mean, we bicker all the time about the law and trying to understand what the law is, and we're saying that you can't even require an associate's degree. It just doesn't. I think we should require more. So that's all I want to say.
Just adopt the amendments before you. It's a second. Everyone's good.
Is this new law that we're adding in the
What page?
firefighter? So if somebody dies, they're a firefighter and they die, they can get this too, right? Oh, that's existing? Oh, okay. I'm just trying to make. Are we helping them throughout a state? I literally had today in my office a bunch of little kids. The firefighter, he was Frederick County, and the mom lives up in Pennsylvania, right on the other side. It would sure be nice if these kids could get something.
Google it.
Looks like the wife of Mary Conroy.
I'm picking up stuff.
He's a veteran, and, maybe the, Korean War had his arm blown.
It will? And that's a new change? I'm just trying to figure out if this passes, I can tell them. And that'll be a new change? Or that's existing law?
But then she took his place briefly when he died.
But if they live, what if in this case, like the people I'm talking about, they lived in Pennsylvania, the guy was a firefighter in Frederick County, and he died this year there. I'm trying to figure out if those kids that live in Pennsylvania can get a scholarship.
I think that the eligibility would require, let me just look, to apply for a scholarship under this section, the following persons are required to be a resident of Maryland at the time of application or at the time of the disabling or fatal event. And so that's that's the page after
They
page
don't,
4. So it's,
I know, hold on, this is important. So, and this is very small number of people we're talking about here. In this case, I mean, literally, they were here today talking about something else. Cute little kids were in there, and I was talking to the mother. They came in talking about the pipe fitting bill, because that's what caused the bad fire. They live right north of Mount St. Mary's in Emmitsburg, but they're right across the line in Pennsylvania. He was a Frederick County firefighter that died. This just happened this year, and I think it would be nice and appropriate that even if you happen to live, if you're a Carroll County fighter and you live over in Pennsylvania, or in this case, a Frederick County firefighter and you lived in Pennsylvania, that those kids could still get scholarships because their dad died, you know, in our area working for us. That's what Jamie's saying.
No, so we changed that. I'm almost positive in 2020, we changed this to say if they were working in Maryland, right? We had the same situation where the family, the mother had moved into Pennsylvania.
No, but that's if they move, but this is if they.
Right, and
But at the time of service, my question is, it sounds like they lived out of state at that time. And what I'd like to do, if we're gonna do this, is say, to make it, in those couple rare cases, like this family, they would apply.
so, just to follow up on that, there's a distinction, because if you go to the next page in paragraph 3, it says that there's enumerated dependents that are listed out there, and it says to apply for a scholarship under this section, The following persons are not required to be a resident of Maryland at the time of the application or at the time of the disabling or fatal event. So one, a son, daughter, stepson, stepdaughter of any state or local public safety employee killed in the line of duty, or the surviving spouse of any state or local public safety employee killed in the line of duty, a disabled public safety employee, the dependents that are listed out there of an employee, public safety employee who sustains injury in the line of duty that renders the employee 100% disabled, or the surviving spouse of a disabled public safety employee who sustains an injury in the line of duty, rendering them 100% disabled. So there's a distinction for eligibility for the dependents living in state or out of state, depending on the context that we're talking about.
So they are covered.
The public safety employees are, but other entities or other individuals who are covered under the scholarship program, their dependents are not. So that's on that paragraph 2. So somebody who died as a result of military service after December 7th, 1941, for example, their dependents would have needed to have been in state.
The following persons are required.
What I'm saying is the actual scholarship money can be used locally in state at the time now.
Oh, yeah,
Right.
The money out of state.
I'm sorry.
Right.
That's what I'm saying. So that's why this is important. Is that now since they're living in Pennsylvania, the money can now go to Pennsylvania, because before we passed this, it would have to go to Maryland. Right.
But the way the bill's written now, with this amendment, it's up to 60 credits out of state. It limits it to up to 60 credits out of state. It was page 6, line 10.
Oh, that's not for the surviving dependents. That's the scholarship that's based on years of service of the law enforcement officer.
This is the law enforcement one.
Right.
Right. Okay, I'm sorry, you just thought, yeah, other one's.
Separate scholarship.
Right.
Can we just clarify, with all the changes and amendments, who's eligible for the scholarships? Who gets the scholarships? What are the criteria for the scholarships? Got it, but, is there an amendment to add the firefighters?
No, they're already in there. I was trying to figure out, but this will say that, so I have it right, because I had a unique case for the family that lived in Pennsylvania, and what they're saying is they're already in the law, but that they could now take the money and go out of state
Got it.
too.
That's the
in
whole discussion about
Pennsylvania.
out of state.
That was the whole thing, out of state.
So yesterday, with the amendment we discussed on the floor, somebody came up to me and said, when you, the bill that we recommitted, when you opened up to the out-of-state, it really could set off a firestorm of problems because we have limitations on scholarships for in-state, for other things. I think he talked to you about it. Was there any merit to his opinion?
So I think the way it works is our scholarships, they're limited to Maryland, our scholarships are limited to Maryland
Unless
schools.
there's a unique.
Yeah, unless there's a unique major offered out of state or something like that. So that's what I think they were saying. And if we now open it up to out of state, for these very limited circumstances, I don't think this calls for alarm there, because this happens, it's so rare.
And the limited circumstances are that you're a survivor of someone that was killed in the line of duty.
Correct.
It is not opening up for officers, no, okay.
Yeah.
I've never had one of these in 12 years of doing a scholarship. I've never had one of these come.
I've had, I get it a lot, actually, people that get denied, yeah. Yeah.
Had someone who's a father was a police officer or firefighter die, is what I'm saying.
Do we adopt the amendment? Further questions?
What? Politically incorrect question, I'm sure. What is the reason that these particular names are on scholarship? And is that in perpetuity, and can we add to it, take away from it? What?
I know, like Delegate Rosenberg has done a few of these, and he's not just, there are a bunch of them that are named in the, that are controlled by Maryland, MHEC, Maryland Higher Education Commission. And they just, they're different criteria. There's public service one that's named in honor of a former legislator who was committed to public service, but you do it through legislation. They hate them. MHEC. Yeah, well, that was not a scholarship program, that's an arts program,
That's like the worst, to be honest.
not a
That's the
scholarship.
worst practice. People who are currently, and we did it for Ed Case-Meyer.
Right.
Nobody wants to vote against it, but like, it's the worst practice. Take current members of the General Assembly and name things after them while they're still here.
Well, she's retired.
That's what I'm saying.
Or the Department of Social Services in Baltimore, named after a currently serving delegate that happened to be on the committee at the time. It's just, okay, I mean, what I'm saying is, I don't understand the nexus between these names and the intent of the scholarships under the bill. Maybe
mean-
there is one.
I mean,
There
Ed
might be
Conroy
one,
and
but
Gene
but
Cryer?
the other ones, there are. Some of them
Oh
here.
no, John
I'll look it
Peak is
up.
here. Where's John?
I know who she was, I just,
I don't know, you're right, I don't know.
There are some,
Ask
I'm gonna
Kathleen
look it
DeMay.
up.
She was friends with Gene Cryer.
I knew Jean Cryer, she was a lovely person, I served on judiciary initially with her. It was just, I didn't know why those names with this.
So for example, like we did last year, the year before, the Richard Collins Leadership with Honor Award. We did that in honor of the student from University of Maryland who was killed. He was also a veteran. Remember that, like 2 years ago?
I do.
I'm just
But
trying.
isn't
There's
the
Janet
scholarship-
Hoffman, Loan Assistance Repayment Program. So Janet, you know who she was, right? She was from Baltimore City. Janet Hoffman.
So I got it, it seems like there ought to be a nexus between the name of the scholarship and the intent of the scholarship, that's all I'm saying.
Totally agree. I think there are in a lot of them.
There probably were, we just don't.
Yeah, we just don't know who they are anymore. And that gets lost over history.
Just remember that'll be all of us one day.
Who was that guy?
Who is that Jill Carter? Why is this named after her? What did
I
she have
doubt
to do
anybody,
with it?
I doubt that's gonna be an issue. I just retire my seat, like 20 years, don't let anybody else sit there and sing the shrine.
A lot of times, somebody's like, I just happened to catch it, and they're like, nobody knows. I mean, Gene Cryer wasn't even that long ago. There's, I think there's 3 of us that probably know who Gene Cryer is.
I never saw it.
You didn't know where she was?
Only because I had a friend. With amendments. It's been seconded, everyone's okay? All right. It's our alpha, all right.
We passed that bill?
Yep. All right, let's go to HB 425.
This is the untraceable firearms bill, and it's in the posture that the Senate saw The Senate version originally, it's different than how the Senate passed it, so the motion would be to conform to the Senate version.
All right, seconded, and everyone just record the same votes as they had before? Okay.
You gotta give me a second then.
All right, sorry. Hold on. We'll slow down.
Okay.
The Senate bill passed already, right? Passed third reader. Yeah.
Okay, well, our work is done.
Yeah, why do we need this?
I know.
Hey, hey.
All right. So just to confirm, Senator Castley, you voted against the bill, but do you want to vote for the amendment to conform the House version of
Right.
The last one's not a Smith bill anymore.
896. It's not your bill anymore? The last one was
The Senate bill, this, yeah.
So, Senate Bill 896 is the modifications to the independent investigations provisions of law for officer-involved deaths. At the last voting session that this came up, the committee voted to conform the Senate version to the House version. It's not a cross-file, but basically the two major differences between the Senate version and the House version are that original authority to prosecute in an officer-involved incident is with the Attorney General's office in the House version and in the version that you have a reprint in front of you with. And then there's also subpoena authority given to the Office of the Attorney General to investigate criminal matters. Currently, OAG needs to convene a grand jury. Court rules also allow them to make an application to the clerk of the court to get a subpoena. This just allows OAG to I shouldn't say just, it allows OAG to issue subpoenas for criminal investigation.
I think this bill will fundamentally change people's impression of the Attorney General of Maryland. Right now, the Attorney General is the People's Counsel, and he and his staff, which is large, advise all the state agencies, and if the state has to go to court for something, the Attorney General goes to court. Currently, the Attorney General has minimal criminal nexus. They handle the appeals from criminal trials that go up to the appellate courts, but that's about the extent of the Attorney General's involvement in criminal law. If this bill passes, the Attorney General, in people's minds from now on, will be defined as that officer of the state of Maryland who prosecutes policemen, period. And if the Attorney General decides not to engage in a prosecution, it will become news on the front pages of the newspapers. And if the Attorney General decides to indict a policeman, it will be on the, no matter what county it's in, it will be on the front page of the state's newspapers. And the news reporters will follow blow by blow the progress of the trial, much like they're following, for example, the trial of Marilyn Mosby right now. Every day that something happens, there's a front page story on the newspapers. And when the Attorney General runs for election at the end of the 4-year term, the only issue that people will be voting on is whether they like what the Attorney General did with respect to prosecuting policemen. He will be known as the state's police prosecutor. I think it's terrible to turn the Attorney General of Maryland into the police prosecutor of Maryland. That power ought to reside where it always has, in the state's attorney's offices, unless the Attorney General takes a look at it and the state's attorney refuses to go forward and the Attorney General thinks it's essential. We passed that last year. I wasn't wild about it, but it's much better than this bill, which takes all the power out of the state's attorneys and gives it to the Attorney General. Do we really want our Attorney General to be regarded from now on as the cop prosecutor of Maryland? I don't think we do.
I would just say that, I mean, right now, the state's attorneys perform this function, and it is not, although some would argue that it could have been politicized in some campaigns, in some areas, it is not the central thing top of mind for the voter, for the state's attorneys. I know what you're going to say next is that, well, their purview is they're prosecutors, so they prosecute a number of things. But I just, when these high-profile cases come up, the same has not been true for the state's attorneys that currently exercise this function. So for me, I don't have the same concerns in that area. And for the investigations, since we passed it, the investigations there's no declination because there's just an investigation and then it's turned over. Right now, the state's attorneys have the exclusive ability to prosecute these cases. There's no second on this. Like, there's no ability for the Attorney General to take up a second. So there's no declination, there's no 45-day rule, there's none of that in the current law. But
Do we adopt the amendment?
yes.
Okay. I mean, how are they gonna figure out, like, right now, because results in death, I've talked to my sheriff, and what they'll say is, basically, is the person dead? I say no. Well, then they'll say, we're not coming out. Like, right now, they're actually very incompetently handling them, is from what the feedback I've gotten. Like,
Sheriff, no kidding.
no, it's not him. It's actually the Attorney General's office. No, with all honesty, we've had a couple shootings, and the Attorney General's office right now says, if they're not dead, we're not coming out. And it's kind of shocking because they'll say, well, you need to be here right in the beginning because what if the person dies? And they're like, we're not coming out unless they're dead. And how the hell are they supposed to investigate it when they're not even out there? I know this gets into it, but then the definition we use is death or likely to result in death. How do you figure out that? What's the definition of likely to result in death?
It's determined by the,
Yeah, they're the ability to do that. I mean, that piece came from there was an incident where someone was shot, looked like they were going to die. They're, I think, whisked off to shock trauma, and then they didn't die. They recovered. And so that's to cover that specific instance. And then we had this question on the record during the hearing when they were talking about the instances where, hey, the IID's office refused to come out, and it was because, and I'll have to look back at the record, but it wasn't an officer-involved incident. And so, they said, look, we're not coming out for this. And I think there was some dispute. So I know Dana, Ms. Mulhauser spoke to this, and we can go back and look at the record on that. But I think
CPR.
yeah, like CPR or something. She provided a pretty comprehensive response to that question, to that line of questioning.
So right now you have a shooting. And they're going to call, the locals will call, because the locals get there first. The locals are going to get there, the local police are investigating, it's all locals involved. And they're going to call, the AG's office, and they're going to say, hey, we shot somebody, and then over the phone or the hospital? Who's going to figure this thing out? Well, where'd you shoot him? And then they're going to, just to get that determination, They're not there. They're not on the scene. They're not there in the initial investigation. You're trusting completely the locals to have done everything in the beginning when it's important, and then you still have this weird quasi situation where the AG is, I don't know, calling the hospital, calling the locals to figure out if it's likely to cause death. I mean, can't getting shot anywhere almost cause death?
I mean, so the way that the bill reads, it's up to their discretion and determination to make that determination.
But I guess that's the fundamental problem with this thing is that you have that issue, and then you've got, what does this do to solve the problem that the AG has, the ones that have caused death, where these things are taking, 6 months in the AG's office to move forward? How does this bill help resolve that?
Well, they haven't, I guess there's one investigation that they've turned over thus far, so this, I don't know if it helps with the backlog. It certainly gives them the resources to do both ends. It gives them more resources to do this, but the backlog, and I don't remember the testimony specifically, but the backlog, I think they furnished one, but it's not a lack of kind of ability to perform the function, it's just the process. That's taken a long time with autopsies and with everything else being backlogged. It's not something that's novel. It's not something that's particular to their operation. It's kind of a system-wide thing.
Well, but I guess I don't get it because, the case I brought up here, we had in the city of Frederick one, the locals cleared it in 2 or 3 weeks. They reviewed the body camera, it was done. The 6 or 7 cases that have gone to the AG, they were basically all sitting there months and months and months without movement. The locals can move it one way or the other. So, I mean, that's a secondary concern I have the process. But the last thing I just am actually curious about is, because I was talking to the Attorney General of Georgia, it was interesting because he was talking about the case down there, the terrible case where the jogger was shot, and he actually talked about how they went in and he as AG, the state actually, they worked to have it moved because the locals were not dealing with it correctly. Just curious right now, I mean, how does that work? Like on other cases, on other stuff like that, is there any other jurisdiction that the AG have? They don't have that in Maryland, do they? Any other jurisdiction? Okay.
So we talked about this the other day, and, I mean, I don't know how many of you all have worked with the AG's office when you're talking about criminal cases, but I have. They don't do a whole lot of this work. When we're talking about criminal cases, they haven't done it regularly. This is a completely new realm for them. They don't have the expertise that these local police departments have in investigating murders, in investigating evidence and dealing with evidence. They just don't have it. And the fact is, I mean, if you have a situation, we talked about one the other day, where you have a suspect and a police officer involved in a shooting, both of them make a shot at the same time, right? So that turns out to likely be fatal. So now you're going to have the Attorney General's office and their investigative unit investigating one side. You're going to have the police department and the state's attorney investigating another side. Then you're going to have a grand jury. You're going to have both different attorneys presenting their cases to the grand jury. Then it's got to go to that same court. This is just, it's setting up a complete bias with the Attorney General's office, and if that's what the intent is, that's what they're doing. This is a bad bill and a bad idea.
Yeah, so it's my understanding that this bill is opposed by all of our county state's attorneys, all of our county sheriffs, all of our county police chiefs. Has anybody got any different result? I mean, so here we are in this violent crime epidemic, and all of our local law enforcement leaders across the state are against this bill, and we're proposing to move fearlessly forward. And we've got a current system. I have not yet seen what the justification was We passed a bill last year. It's there. No one's come before us and said this is not working, that they're unable to do what they want. In fact, they've not taken over any of the cases that they've seen. So we've got a system we got a proposed bill that's opposed by everyone. We have a bill we passed last year that is working with no evidence to the contrary. And so I guess my first big question is, what are we doing here? This doesn't pass the smell test at all. And then moving beyond that, you do have the question of my own county. We had the most recent was where the cop walks in and checks on the guy in the local, walks up to check on a guy in a local eatery, and the guy pulls out a handgun and blows that cop away, kills him. He then flees to the parking lot where he shoots another cop dead, and the other cops respond, and finally that guy is shot dead. So now I have 2 dead police officers and the 1 dead shooter. What this says is, okay, what the state's really interested in is the dead shooter, and we're going to put that interest above all else, and we're going to take the AG's going to take over the 2 dead cop shooting as the lead prosecutor. I guess the local state attorney then keeps the prosecution of the 2 dead cops, but the primary investigation is about the shooting of the evildoer, and that's what we're most interested in, and that's what will drive this investigation and this prosecution. And so if the AG screws up that one it's all the same witnesses, everything's the same, the ballistics, everything is identical in all 3 killings. And now I have an AG out there who's the lead investigator, and to the extent that they botch anything, you've just sealed the case on the other two. And then I mean, just as a practical matter, this is totally unworkable. And then my final point is, the U.S. Attorney has a fine model that no one has ever assailed, where they have the ability to come in if they think someone's civil rights might have been deprived, which if you shoot somebody, if a law enforcement officer shoots somebody without just cause, or uses unnecessary force, then the U.S. Attorney can come in, even now, even into our states, and look over this and review the entire investigation. They can do it while the investigation's ongoing if they think something's untoward. And they have the ability to review everything, and then they can do their own prosecutions if they think that the locals are going amok. Seems to me that's the model we ought to be following, because why? Because it makes sense. Because the shooting takes place, and everything's going to be, all the critical evidence is going to be gathered up in those first few minutes, those first half hours, and it only makes sense that the lead prosecutors are the local people on the scene who are supervising the investigation by the local police. Why we would jeopardize all of this for no reason at all, for no rationale, against all the advice of every law enforcement person in this entire state, elected and unelected, just totally baffles me. And I would urge the committee to think really hard and seriously about this one. Thank you.
So I thank you, Senator, for that. That makes, it's very crystal about that incident. And that is an issue that really does bring it home. But let's say that person that the AG's was coming to investigate had happened to be a police officer gone bad. And that police officer goes against the responding police officers. And the same scenario plays out, right? Does the AG, and the way this bill is worded, does the Attorney General come in for that? No. Right? You know why? because the person was a police officer, right? They have no interest whatsoever in that person, even though he was a criminal, right? It's a dead police officer, and what does this bill say? And what does the Attorney General say about that? Are they interested in it? Not one thing. They're not coming to investigate. They're not using that investigation group that they used. They're not doing anything. They're not coming, and that is wrong.
Even my own county as an example again, goes back, I don't know, 30 years ago, we had the shooting on the Tidings Bridge, where the guy, a vehicle stopped, cop comes up to see why is the vehicle stopped. He shoots that cop. He then proceeds to shoot like 3 more cops before he finally gets off the bridge, big manhunt, then of course there's more shootings there. So now this investigation now would be taken over, I mean, huge tons of cops everywhere. And so now that investigation, because the shooter gets shot, that investigation will be taken over by the Attorney General, potentially, who's now mucking around where you have all these local investigators from multiple local jurisdictions are heavily involved in the investigation, and now they're going to all be responding to a chief investigator who they've never worked with, they don't know, who doesn't know them, who doesn't know their capabilities, their qualifications, which agents, which cops are really top investigators, which ones you probably want to push off to the side, not rely on heavily. That's who's running the investigation. Somebody who knows nobody on the ground, none of the team. And here I've got on the ground experienced prosecutors who know their police force, know what their capabilities are, who are directing this investigation, and they're going to be supplanted by somebody who doesn't know anything at all about the capabilities, the local terrain, the local people, none of that. It just seems like such a backwards way of doing a prosecution that you would supplant all that local knowledge, capability, experience with somebody who's going to be coming out and may have been hired from Idaho 6 months ago and knows all that, has all that intimate knowledge about some county in the state of Maryland and the local police and the local citizenry and the criminal element, et cetera, et cetera. That's your lead investigator. I'm sorry.
With amendments, it's been seconded.
Did you adopt this amendment?
We did.
Okay. Is everything good?
So it's going to roll call.
Vice Chair Waldstreicher,
Yes.
Senator Lee,
In the current form as in here, right?
With the amendments.
With these amendments?
Yes.
Yes.
Senator Castley,
No, to the dumbest bill of the year.
That's not true.
Senator Heddleman,
Not the dumbest.
Do you call it
Yes.
cats?
Yeah.
Senator West,
No.
Senator Sidnor,
Yes.
Senator Watson,
No.
Senator Bailey,
No.
Senator Carter,
Yes.
Senator Huff.
Just real quick, explain my vote too. I mean, I do agree that this bill is political and silly because if you think about it, if a police officer shoots somebody in the spinal cord and the person's paralyzed for the rest of their life, the AG doesn't investigate. So now we've created this crazy category where they do. So somehow it's not, it's fair and impartial for our locals to do it if somebody loses a limb or they're shot and they're paralyzed, but it's not in these other cases. So it shows really the unfairness of this law that we're passing. So no.
Well, I don't, the way I see it is it's a starting point, and that if there is a need, once we begin this process to expand on it later, we certainly have the ability to do that.
Of course they're gonna expand it, because
last year.
there's no logical justification for what we're doing.
Process.
It's already.
Chairman Smith.
All right, yes. I know, I know.